Hi everybody, this is Paul Edwards. Welcome to today's webinar. We're going to talk a little bit about employment law. I don't think we have to linger on this second slide very long. We all know who Douglas is, and I'll get into a little bit more about what our relationship, Doug's and my relationship, is together. I know I have a blend out there of asset protection attorneys, financial advisors, different folks that work in those fields. And Doug and I were talking, and one of the things that we kind of landed on was we know you guys are often at the front line, and you're getting questions from your clients, and sometimes it's easy to answer them, sometimes it's not so easy to answer them. So I just kind of wanted to give you some guidance, based on some of the things that our company here at Cedar HR Solutions sees. So let's just kind of look at, we don't have to talk about me too much, but I do want to explain why I'm on this call and why I might be able to help you guys out today. I think it was about 2006, Douglas had been working with all of his clients on asset protection. He was paying close attention to the Supreme Court ruling which occurred, I believe it was in 2001 or 2002, where they kind of put the hammer down and said that, look, if you want to put arbitration into employment context and use it in employment context for heading off trouble and requiring employees to report an issue before they can sue you, we're cool with that. And of course, over the years, the Ninth Circuit has fought that. It's kind of gone up and down, but in the end, that turned out to be a pretty wise move on Doug's part. And so he created the alternative dispute resolution procedure contract that we use a form of here. Now, what does Cedar do? Well, what we do now is we service over 1,800 dental and medical practices and related businesses to those practices. So that means, we have everything from acupuncturists, we have physicists who search for moles on people's bodies, we have all types of specialties that come to us. And what we are essentially are an HR consulting firm. What that means is that if they're having an issue with an employee, it can be a difficult, problematic issue, or it can be something very simple. They come to us and we help them through it. We maintain a group of about 12 highly trained experts that take those calls from our members, and we help them through their issues. We do a lot of the work for them. We have systems in place, software in place that helps them as well. But before we do any of that, we require that each and every practice gets a fully customized employee handbook in place. So that means that once they have our platform, that handbook in place, which is totally compliant, knows the number of employees that they have, it knows what their municipality is, it knows which state they're in, and it knows obviously what the federal rules are that do apply to them or don't apply to them, which is just as important. You never want to apply policy to an employer that doesn't need to follow it. So anyway, we go to great lengths to get that customized for them, and now that gives us a way for us to solve their issues. And I'll talk about this model a little bit more towards the end of today's conversation. So, take it away, Paul. All right, so I'm going to take it away now. So what we're going to talk about today, some of the things that you're going to learn, and I got to get this, got to get something out of my way here, everybody, so I can see it. Well, we're going to talk about employment law basics and how to identify some of the common HR threats your clients face. I think that's going to be the best part of this. I do want to jump in a little bit about and discuss at-will employment, why it's so important, but I also want to talk about why it's not really a silver bullet. And when I talk about a silver bullet, I mean something that can magically prevent opposing counsel or a government agency from taking action against an employer over terminating an employee. And then again, we'll get into our model, and I'll share with you, maybe get your juices flowing and you can figure out a way to take advantage of the monthly recurring income model that we use here at Cedar. So let's talk about some of those threats and why it's important. A lot of employers really don't recognize that you can do things, well, you can do things two different ways. You can get frustrated with people and you can create a policy, and I'll give you an example. You can say, look, everybody, you know, in the back of your mind, you're thinking about the big upset that just occurred in your office, or they're thinking about what just occurred in their business. Two people started talking about their salaries, and the next thing you know, everybody's talking about salaries, and there's a big upset going on there. So what most employers do, and most of your clients do, they create a policy. They say, look, if you talk about your, you know, no sharing salaries. Salaries are confidential. This is confidential information, and if you share salaries, we could fire you. So that takes me back. So we put a little pin in it right there, and we take a step back. There's two ways that you can address this issue with these employees who are discussing their salaries. I'm going to tell you that the policy that I just stated, which is in just about 99% of all employee handbooks that get sent to us for review, is incredibly illegal. It violates really two federal laws, the National Labor Relations Act and all the laws and regulations that go with that. It also violates the Lilly Ledbetter Act of, I believe, 2009. Basically, what you all should know out there, and this is a common issue that I'm talking about right now, is that you cannot have any policy, you cannot take any adverse actions against anyone when it comes to them discussing their benefits, their wages, or their working conditions. The National Labor Relations Board, which enforces the act, have been very aggressive, and I got to tell you guys, we found them twice in small businesses which we were servicing or in the process of servicing. In one instance, they had a policy which again violates the National Labor Relations Act that's very broad and forbid employees from posting negative comments on Facebook about the doctor or the practice. Again, something that sounds like a reasonable policy. But that is not legal, because that would tamp down their rights to discuss those things that I just laid out for you. Anyway, they had an employee who was in a fight with their manager. I think they had about 16, 17 employees. She went home, got on Facebook. She was angry. She was upset that she was being kind of forced to work more hours than she thought she was going to have to work. She said something to the effect of, if I'd known this new program that we were putting in place was going to take me away from my kids and make me work 47 hours a week, I never would have worked there. And I keep trying to talk to my manager about it, and I think she's stooping the dentist, you know, something like that. She implied that they were having sex. Well, this wasn't true. And of course, word got out, got back to the doctor. She walked in. He promptly called her in. Of course, they had not consulted with us, and told her, you know, that wasn't cool, and he was hopping mad, and he fired her over it. Well, she went to her neighbor, whose husband was an attorney, and he immediately recognized that this was a problem for the employer. He helped her to file a complaint with the National Labor Relations Board. And about $65,000 later, we were finally able to talk the doctor into not fighting this any further. The National Labor Relations Board, you know, they're judge, juror, and executioner. So I'm sharing that story with you because these things can spin up and out of control quite quickly. And the next thing you know, he had to reinstate her, pay her back pay, had to pay fines to the board, had to pay his own legal fees, had to pay her legal fees, and the worst part was he had to stand in front of his 15 employees and read a statement which was written by the adjudicator for the board, outlining to his employees what he had done wrong, and you know, basically is really pretty embarrassing. So this comes back to the handbook and the policies. When we put the policies in place, the first thing we're doing is we're creating consistency, and that's what you always want to have. You want to be very careful about creating inconsistencies even in a small business. Well, I think one of the great examples that I see is I'll get a handbook in from a practice that has 15 employees. The majority of them are female, if not all of them, with exception of maybe one or two. And they'll have a handbook that a local attorney has done for them. The attorney has advised them they've been correct in telling them that they're not required to give a leave of absence for employees, and therefore they should not have a policy in their handbook which ties them to having to give it. In our view, this is not great guidance. It's not great practical guidance going forward. The fact is that with 15 female employees, the chances of them needing to take pregnancy leave are pretty high. So that leads us to the next thing. Why don't we have a leave of absence policy which is reasonable, gives them 6 weeks of unpaid time off, sets requirements for notice for coming back if they don't give us notice that they're coming back, within a certain amount of time after going on leave, that it's considered they've abandoned their job, and also what they need to do in order to return, go to their doctor and get a certification that it's okay for them to come back to work. So we'd like to put all those things in place. It's very, very protective. So you can see where I can be at odds with a local attorney who's saying, look, you don't have to do it, don't do it. And I'm saying, well, you don't have to do it. I want you to create some consistency here. And frankly, over the next 5 or 6 years, you're going to have different people going out under different circumstances with different health issues, and they all need to be treated the same. And who can remember what you did a year ago with another person when they requested extra time off from maternity leave because of some health condition? Who can remember exactly how you handled that, what your policy was then, if you don't have it written down and you were just kind of playing it out? And that's the other thing. Look, you may not write a policy down, but your practice and patterns and what you do actually are a policy. So you could either create the policy and be consistent with it, or you could wing it, but you're still creating a policy and an opportunity to not be consistent. The other thing that I want to really reinforce is that compliance with state, federal, and municipal laws is kind of new. State and federal has always been important, but municipal has rarely been an issue up until about 5 years ago, really 4 years ago. And now the area where I'm seeing the most action in municipal laws, and some of it's statewide too, but mostly municipal, is they're passing these paid sick leave laws all across the country. We now have over 40 different municipalities or states which have passed different paid sick leave laws. In New Jersey, they couldn't get it through the state, so they have 7 different municipalities in the single state of New Jersey, and all 7 of those municipalities that have passed paid sick leave have passed a different version for compliance. I think one of the most interesting things, and all of you should know this, is that all of these paid sick leave laws are modeling off of the first ones that got passed in California and Seattle. And what they had put in those policies were policies about retaliation. And so in most cases, if you fire an employee within 30 days of them taking paid sick leave, which is mandated by the state, if you fire them within 30 days of doing that, it is presumed that you have retaliated against them. In Arizona, we just passed ours. By the way, everybody, we're located in Tucson, Arizona. We service all 50 states. We have multiple clients in all 50 states. In Arizona, the law says that it's 3 months. And so since you can earn 4 paid sick days per year, the attorneys here, when we first wrote the first set of guidance, came downstairs and said, well, if I read this right, this means that if you just take 1 sick day per quarter in the state of Arizona, you're protected. It's going to be very difficult to just exercise your at-will status and step in and fire someone because, they've taken a sick day in the last quarter. So anyway, it's getting very complicated. So if you have someone that says to you, I'm having trouble getting you my reports because I have this manager who is not working out very well. She's been with me for a while, but now she's starting to take a lot of days off, and I'm thinking about getting rid of her. That should be a signal for you to know that there could be paid sick leave laws there, and you should know these things, and how they might proceed more cautiously. It's not that you can't get rid of somebody after they've taken a sick day. It's that if you have not documented it and you can't show why you're letting them go in any way, shape, or form, well, then everybody here knows what happens. We all end up in a courtroom someplace arguing over what the meaning of the word is. And so in this slide in front of you, I say quite literally, avoiding a problem is always the best defense. Well, I have we have 12 attorneys that work for us here, and I have other attorneys who don't agree with this. They think the best defense is the defense that is $275 an hour, and they're in court. And of course, we're on the other side of that. We're trying to keep them from ever having to end up there. So I'm just kind of looking, something else I want to share with you about the paid sick leave. Most of them carry some kind of a tracking rule, posting rule, and an acknowledgement of the requirements. And so with that, you're going to want to know that just because your client has been paying someone or has provided paid sick leave or a PTO policy does not mean that they are in compliance with the law. And in another example, I'll just use Arizona. We actually have to track the accrual and the used days and report them in separate places on the pay stub. The other thing I want you guys to kind of think about is I want your clients and I want you guys to understand that there's about 150 ways that your clients can access protections that are built in for them. So we call it, accessing the laws that protect. Properly written harassment policies, properly written problem-solving policies, properly written problem reporting policies can be very, very powerful tools to put in place for a business. Now, you can write them wrong. You can do what I call, I often advise, you want to help them help you. The them is the EEOC or even wage and hour. So if wage and hour comes to you and they say, look, this employee, you just got in touch with us, said you weren't paying them overtime properly. And you can respond to them by saying, well, got a few things here. First of all, you should know I just fired them, so they're no longer an employee. And they may be upset with me. Second thing you should know is I have a policy that clearly states that if they have an issue with their pay, they don't think it's correct, that they won't be retaliated against, and they should let us know as soon as possible, and we'll correct it. And then I have other concern reporting policies. And I want you to know, here's a copy of them. Here's their acknowledgement that they got that policy, and that they've never told me this. There's not a single word there. Well, what you've done is you've helped the wage and hour investigator out quite a bit, because now he or she can turn to that person who's filed the complaint and say, well, you have these policies. Why didn't you tell them about it? Why are you bringing this up now? And this just leads to, what it leads to is getting the problem solved instead of standing there and defending yourself. Now, of course, all know your clients should have all their time cards, keep them for 2 years, do all those things. Now, I'm going to give you an example of another policy that I see that is improperly written. The policy says that you have 2 weeks to bring up your concern. After that, there will be no adjustments to your pay. And I see this policy quite a bit. Just want you to know that's the sort of thing that someone wrote because I got sick and tired of people showing up a month and a half later going, hey, I just went back through everything and I found $4.75 you owe me, a little short on gas money this week, and could I get that? I know why people create these things, but again, as professionals, we've got to be very careful not to problem solve without taking into account all the rules that would apply. And I would submit to you, like the policy that is, no discussing your salaries or, working overtime is futile, we won't pay it. That's another one. I mean, I've shortened it, but it usually says something like that. All of those are more, they're more evidence than they are anything else, not really good policies. Another place where I see a lot of failures is, it's funny because I'm going to go into this a little bit in the next slide where I talk about at-will employment. I actually see a lot of places in employee handbooks where at-will employment is being assaulted. There are phrases or even agreements being created within the policy handbook itself, which then create contractual agreements, which then set aside the at-will nature of the entire employee handbook. And so, again, just highlighting for you, if those things are in place and they're not proper, your at-will status is out the door because you've got something else in writing that implies a contract. And then the last thing I have on this page, but I have a little bit more. Last thing I have on this page, though, is properly classifying employees. I would expect with the folks that are sitting on this that you all understand exempt versus non-exempt hourly employees. You probably all understand or are aware of the fact that classifying someone as an independent contractor when they are in fact an employee is quite a dangerous thing. In states like California, Massachusetts, I think New Jersey jumped in on this. They've made it almost impossible to classify someone as an independent contractor for employment classification purposes. So again, want you all to be very, very careful if you're going to give someone the guidance to say, well, hire them as an independent contractor, or you notice as their taxes are coming across your desk that people are classified as 1099 employees. I'm just going to give you one question to ask yourself. Is this person who's working for your client performing the main work of that business? So in our case, because we work in the vertical of dental and medical, if I've got a general dentist and he's hiring a general dentist to come in and work part-time, that general dentist is an employee. They are not an independent contractor. And it doesn't matter if they have their own business, and it doesn't matter if they work for 2 or 3 other practices. All of those things don't matter in the greater scheme of things because they're doing the work of the business. Now, if I have a general dentist, but he doesn't do any ortho, he doesn't do braces, and he decides to bring in that specialist, say every 3rd Thursday, and have that doctor, that specialist do ortho, then that person could be classified as an independent contractor. And of course, all the other components would need to fall in place. So again, be careful about your allowing your clients to just wander down the independent contractor path. And what I'm going to do, I didn't preload this, I wish I had, for everybody who attends, who's here today, I'm going to send you just a great article, a listing of the classification differences. And you can go through and refresh your memory. You may learn something new. And we've given you links out to the federal site so that you land in the right places. Let's see, what else can we talk about? I'm just going to go down, I'm going to give you all of the policies. I'm going to give you about 12 policies that are always wrong. So here we go. A policy that says no gossiping is illegal, breaks the National Labor Relations Act. A policy that says no disrespectful language may be used with employees and managers or owners. In other words, you have to speak respectfully. It may not use foul language, yada, yada, yada. If it includes management and the owners, that policy is illegal. It breaks the National Labor Relations Act. In their findings, and I'll paraphrase, they're basically saying you can say whatever the hell you want, any way you want to say it, when discussing your benefits, wages, or working conditions with management. Now, can they stand up at the front desk and start screaming profanity at you over their pay? No. And can they do, can they just start complaining they're not getting paid enough and now they're protected? No, that's not the case. But can they come to you and say, I don't think I'm being paid fairly because she makes more than I make? That is protected speech right there. And you're going to want to be very careful about asking, has anyone complained about how they're being paid? In other words, I'm not being paid properly, or have they compared their pay to someone else? If someone has done that in the past 30 to 60 days, then you want to throw up a red flag and say, look, just be careful here because they did that. It could look like you're retaliating against them. And in all likelihood, that's probably part of an overall upset that's going on with the employee. But without knowing it, they've inadvertently put themselves in a protected class. I talked earlier about no sharing salary info. That is not legal. All things here at the business are confidential. If you reveal any of them, if you say anything about, if you reveal anything, it's just all confidential, and we could dismiss you or sue you or take action against you or whatever. That is not legal. You must now narrow what is can be considered to be confidential. So all things are confidential is way too broad. Our pricing, our methods of operation, our patient records, and other things of that nature, if you were to list these things out, can be confidential, are not overbroad, and do not imply that they cannot discuss other things related to their working conditions. Another one, cannot make disparaging remarks about the business on, over email or Social media, completely illegal. Can't have that policy. Cannot use the company logo without permission. They took that away from us about 2 years ago. If someone wanted to put up a complaint about the company and say, you know, it's terrible working there, they crush us, and I feel like they're changing my time cards, and I'm not being treated fairly, like, you know, I'm being paid less than the males, and they put up the company logo. You can't use a gotcha and go after them on the company logo. So now all of those were kind of with the National Labor Relations Act and are often shocking for those who not heard this talk before. I'll go down a few others. Telling your employees that they have to return all the property before they can get their last paycheck. That is not legal. That's conversion. You can't do that. If they've got your laptop, or, you know, it's the manager of your business, she's got your dog, your laptop, and your dry cleaning, what you can say is give them back. You need to pay that person their final paycheck in accordance with state law. Some states require it to be paid at term. Others require it to be paid at term within a certain number of days. Most say that if an employee voluntarily quits, they're not fired, that they just have to be paid by the next payday. You're going to want to go ahead and get them paid and ask them to return your dog, your laptop, and your dry cleaning. And if they won't, you just simply put in a call to them, or leave a message, or send them an email and tell them, look, if I don't get it by this Friday, I'm going to consider it stolen. I know who stole it. It was you. I'm going to call the sheriff, and I'm going to send him over there for my stuff. And if I have to file a lawsuit against you, I'm going to go all the way with it. And generally what you'll find is your dog on your front porch, your dry cleaning in your front yard, and your laptop will come flying through the front window, but you'll get all your stuff back. You won't be in any trouble. Telling them they have to give notice in return for something can really be not a good idea. Many states say something about, or they classify vacation as a wage. So once it's earned, it must be paid out. And that means at termination, if they've got earned and accrued time, that they must pay that time to the employee as part of their final paycheck. And I see this, you know, if you give us 2 weeks notice in return for, and in return for that, we'll pay you out any unused vacation time, conflicts with state law, which says you don't have a choice there. The other thing is in general these days, I think we all recognize that I don't want 2 weeks notice for the most part. I mean, maybe when we were a tiny business and we only had one person who were answering the phones and knew how to work them and stuff, I might feel that way. I might feel differently. But once we've decided you're not a good fit, you don't want to work for me anymore, and I don't want you to work, or I don't want you to work for me anymore, I don't want you here for the next 2 weeks, and I certainly don't want you training your replacement. Another rule, another clause or attempt I see made, and this happens a lot inside of dental as well as medical, are an attempt to place golden handcuffs on employees in return for something. So you're like, you know, I'll pay for this course, but in return for that, you've got to continue to work here for the next 6 months or year or whatever it is. And this, you know, on the face of it, kind of makes sense. If I'm going to invest $5 grand teaching you how to do a new procedure, which is really going to be good for the practice and for you, I should get something back for it. But the problem with that is that at-will employment says that you or I can end the relationship at any time for any reason or no reason at all. That's the definition. And with the caveat that we can't end it for an illegal reason. What are some of the illegal reasons? Well, I listed them. You shared your salary information with someone else, so I fired you. Made a workman's comp claim about 45 days ago, and it turned out that it wasn't a valid claim and that you weren't awarded it. That would be, even then, if you fired someone, they would still be protected there. Clearly, you know, you'd never step up to someone and say, you know, wow, 4th pregnancy, I'm letting you go today. You know, we all know that that's one of the protected classes. So you have public policy protection, taking jury duty, you know, whistleblowing, bringing up concerns about billing or some other activity that you don't think is legal, puts them all in protected, puts them in protected classes. Now, back to the golden handcuffs and why that becomes a problem is because once you say you've got to continue to work here, what happens if the next day or a month from then or 2 months from then they want to leave, or you want them to leave, and now we have this kind of subcontract sitting there. So what we like to do to cure that issue is to say to someone, if you want to go take this course, you will have to pay for it. However, if you're still here 6 months from now, we will reimburse you for that course. And that works a lot better than actually trying to create some kind of broad handcuffs on this person in a contract that would take into account everything. And then the last one that I'm going to mention in this little section of the module is training pay. I've yet to see someone who passed me a policy that's correct when it comes to training pay. Again, because we work in dental and medical, those guys are guys and gals, doctors are often taking their teams out for training, seminars, association meetings, and stuff like that. And what they don't realize is that in all those instances, they have to track those hours and they must pay those hours, and that employees cannot volunteer those hours away. They can't say, I'm doing this voluntarily and then therefore I'm not owed that pay. That's just not legal. And a lot of people say, well, but there is this clause that says if it's voluntary. It doesn't apply to things that are associated with the work that they do on a regular basis. So, ad nauseum, there's a bunch of stuff I kind of threw against the wall for you guys, so you can kind of have a little bit of a red flag there if one of your clients is frustrated and start asking you about what to do about a particular employee situation. At will employment, let's just kind of jump in there. I think it's one of the most widely misunderstood areas. I think I already covered how you can damage your at-will status. You can damage your at-will status also by writing a corrective action for someone and requiring them to agree to it in order to continue to work there. Now we're creating a contract. We want to be careful because the thing that we've identified, they may correct, but now what if we have another problem come up right in the middle of that? Now we have a problem because we've got an agreement in place that says that if they improve in this area, they get to keep working there. So you always want your employees to acknowledge things, but you want to be very careful about having them to agree to it and thereby creating a different relationship with that employee. There's another policy out there that's it's a fair policy. That policy is what we call a 3 strikes rule or some kind of step rule. When you mess up, we're going to do this, and if you do it again, then we're going to do this next thing. So the first thing we do is we're going to talk to you, and the next thing we're going to write you up, and then the next thing we're going to write you up even harder, and then the next thing is we might fire you over it. That is not an at-will policy. An at-will policy says that we have these tools at our disposal. They include conversations, notes about your performance, written conversations, possibly an affirmative corrective action, and then finally we have termination. We have all of these tools at our disposal, and we reserve the right to use those tools in any order, out of order, in any way that we want to. And, written properly, this supports you when you go to an employee and you say to them, look, you're late a lot. It's habitual. I'm letting you know that I'm reminding you the policy says if you're habitually late, you don't call in properly, we're going to let you go. We can fire you for it. I'm reminding you of that. I'm telling you that you're habitually late now and that the next time you're late, I'm going to terminate you. If you do that, if your client does that, then they'll have a much better chance of avoiding unemployment and of having no issues with it. Another piece of guidance I get is don't state the reason when you fire. Just don't tell them. Just you're an at-will employer. The problem with that is that if you haven't been trying to correct their behavior and coach them and get them to be better and documenting those things, then it becomes your word against theirs. And when you don't give them a reason, A, it's a surprise because you haven't been coaching them, and B, they become suspicious that all of a sudden you fired them and you're not giving them a reason. Without exception, this has been one of the most important components to us keeping our clients out of trouble. To give you an idea, we take about 12,000 calls a year. We've been doing this for 10 years. We've had 2 clients successfully unsuccessful, they had to settle. So out of all those tens of thousands of calls that we've gotten, just being clear, documenting, and giving a good supportable reason, doing it in the proper way has always been what we find to be the best course. And I just want you to, I'm telling you on this slide here, it'd be probably a good idea if you pass that information on to your clients. The question should be, well, have you talked to her about it? And have you told her what the issue is? And have you talked about what the impact is on the business? And, have you let them know if they don't correct something's going to happen? They may not be working there anymore. If you do those things, you'll find that a lot of times people, you call them in and they'll be like, I'm fired, right? And be like, yeah, we talked about this. Let's get this ball rolling. So, at will is very important. You never want to lose it. We lean into it heavily. We don't encourage contracts with employees unless they're upper echelon employees, associates. We put employment agreements in place with hygienists and other people in the medical field, but for the most part, no contracts with employees. You want to have well-written employee handbooks and policies there. So let's jump to the last part of the presentation. I was talking to Doug. By the way, Doug's speaking right now. That's why you're stuck with me for the next few minutes. I was talking to Doug, and I was like, Doug, what are these guys, what are they trying to do? And he's like, man, they're like you and me. They're trying to keep their clients. They're trying to make their clients happy. They're looking for ways that they can create more value with their clients. That's part of the reason why you're working with Douglas. They're just looking, the same way that all of us are, is to, I don't want to say get the most you can out of your clients, but to be of the most service that you can be to them, and consequently to increase your income. And so I would just share our model with you guys, just straight up. And maybe you can see in my sharing how you might use the same model to support something that you do on an ongoing basis for your clients. The old model was go to an attorney, get them to write your employee handbook. The attorney would give you the employee handbook. You put it in place and everything's gone. That's it. We're done. There may be some updates here and there. You might have to call the attorney every now and then because you recognize that you've got a serious issue and you need a little bit of help. The new model, and the one that we created, is that they pay us an upfront fee for the employee handbook. It takes quite a bit of work and coaching. We put 2 hours into the employee handbook with them on the phone, customizing it, explaining to them, the basics of employment law, what it means to be a small employer. That costs them about $3,000. After that, we ask the question, what's going to happen when you need help? And believe it or not, they need help almost every month. From the hey, I was reading this article and I was getting ready to call you about firing this employee, but I know now, I need to let you know, she filed a workman's comp claim about a month and a half ago. The claim wasn't successful, and in fact, I think she kind of lied to the investigator and lied to me, but she's still working here, and overall, it's just been terrible, and I'm ready to let her go. And in this case, we would probably say, okay, well, we have lots on record. We've been giving her warnings. We think she filed that complaint right in the middle of all of this because she knew her head was on the chopping block. Now we can weigh whether or not it's safe to let this employee go. If we're talking to a brand new client and they tell us that, we have nothing in place over their behaviors, then we would say to them, look, you got to back up a little bit and let's do some documentation and let's make this a lot safer by kind of creating the case for this. So that means they need access to experts. So what we do is we charge a business with between 0 and 10 employees $150 a month for unlimited access to us. So you may look at that model. Now, unlimited access doesn't mean unlimited service on everything. It means unlimited access for us to solve the problems where we are specialists in the problems that they are having. So they can't call here and ask one of our attorneys what to do about a patient that's not paying their bill. But they could call us and say, what do I do about this patient? They're harassing one of my employees. She's just reported that this guy grabbed her butt when she walked by. What do I do? In that case, that falls into our purview as human resource specialists, and now we can help them out. And we'll talk to them about what they can do with that patient and, how they might want to handle that on behalf of the employee. We're going to handle the employee side. We're not going to write any letters to the patient or do any of that. It could be something that's quite simple. I have an employee, I used this example before, they need maternity leave. What paperwork am I supposed to give them? And then it falls in between, guys. I have all kinds of stories of reasons I get calls. I'm just trying to think, what was the last one? The last one I answered, oh, this is not good. Oh, what the heck. we're all adults here. The last one is small practice, has 12 employees. They have 3 operatories. They're sitting in about, I think, 1,200 square feet. They have a new employee, and when she uses the restroom, which is centrally located, it creates an odor that doesn't go away. She seems to be oblivious. She's doing this twice a day. The whole practice is stinking up. She's a brand new employee. And, you know, I mean, you can't test for this when you're interviewing new employees or new potential employees. You can't interview for that. So you can't ask questions that'll get you that answer. So now they've got this problem that they have to deal with. I mean, I got stories. When there is a way to deal with it, you can talk to them, and there is a concern there. If she's got a medical condition that's causing this, we've got to be cognizant of that. It doesn't mean that we can't say something about what's going on. It turned out okay. I'll just tell you guys that it turned out okay. So as you can see, if you've got an employee problem, you call us. Now, I know I've got financial planners out there, advisors. Heck, if you're an attorney out there and you provide employee handbooks to your businesses, charge them $500 a year for a recurring. Comes up every January. You put a system in place, you update their handbook form, you give it back to them. I guarantee you they'll be happy to pay you that $500. If you're an advisor out there and at the end of the year you get to something and you're like, wow, man, my life would be so much easier if I didn't have to wait for my client who knows what they're supposed to do to gather all of this information and get it to me. If I didn't have to wait for all that, my life would be so much easier. So maybe you charge them something like $75 a month. You get a portal that they can upload their stuff into, and then you just say, look, your job every month is to take all of these things that we gather, put them up in the portal, I'll pull them down, and then for them, it makes their life easier at the end of the year. For you, it makes your life easier because you don't need to do this as the planner. Your assistants, your employees are pulling that stuff down, and at the end of the year, instead of you waiting around and pulling all the information out of your clients, you just are waiting for that last month. You hit a button and you're ready to go. So what I like to do is I like to look at something that I'm already doing, and I like to try to figure out how I can monetize it so that my ongoing efforts to keep my clients happy also result in me making extra income and hopefully just making everybody's lives a little bit better. It is important that you understand that you need that upfront fee or that large fee at some point. I think you all know that. You charge something for doing people's taxes or for doing their planning or for maintaining something for them. You always want to get that larger upfront fee, and then you want a smaller over the year fee. You know, some people, the way we do it is we say, look, you can pay it all up front. I'll give you a 10% discount. We put them in a 2-year agreement. You don't have to do that. You can just do a 1 year with them, or you can do month to month. And you can frame it any way you want. Look, it's only $75 a month, or it's only, you know, $950 a year, $1,000 a year, whatever, you know, whatever you want to make it. I guarantee you that you're doing something for your clients that they would appreciate if you did for them on a more regular basis. I promise you that there's something that you could be doing for them that doesn't require you to do it yourself. Maybe there is something that you can do that's of a high value. If it's of higher value, then you can charge more for it. And then, you know, that's kind of the model, guys. We just kind of figured it out. It made sense with HR, but I'll bet it would make sense for any of you as well. So with that, I've imparted all the knowledge I have, and I'll open up the floor. If you guys have any questions, please feel free to type those things in, and I'll be happy to answer any of those questions. I think I have Brittany on the line, and I don't know if I have to pass this over to her or not. Brittany, what do I have to do? She's on the other side of the building.
If you just stay
oh, great.
right where you are, that works. Looks like the first question is, are there any materials for this presentation? I can actually answer that one. We will be sending this out by the end of next week, the recorded webinar for everyone that attended.
Okay.
And then the next question that we have is, I keep hearing the term right to work. Is that the same as at will?
You know, that's a great question. It's a mix-up. No, right to work states are states that have, their legislatures have passed a law that says that it's a union-busting legislation. Right to work states are states where employees cannot be compelled, even if they're the member of a union, they cannot be compelled to pay union dues. And so at will and right to work have absolutely pretty much nothing to do with each other.
Okay, and then the next question is, how do you bill your recurring income clients?
We just use, there's all kinds of software out there for that, guys. It's pretty easy to do. You can go to authorized.net and set up accounts. You're probably already running credit cards for some purpose. It's pretty easy to turn it into recurring. You just set up a module. Just do a little bit of Googling, look at authorized.net. They even have a kind of a guerrilla style of recurring revenue. And, you know, our clients just expect that to come in every single month. So we don't invoice, we invoice for the first part of it. Past that, we only invoice where it makes sense. The recurring revenue that's coming in every month, invoices are not going out.
Okay, and the next question is, can I send someone who is having a problem to you guys?
Well, that's a good question. You can, as long as they're in medical or dental. So that's the thing. I can't, here's my thing. I can't provide good HR support. Look, the law is the same for the local pizza place as it is for the local hairdresser, as it is for the local dental office when it comes to wage and hour. Pretty much the same. I mean, there are some subtle nuances on the pizza place, but nonetheless, I don't know what goes on in the back end of a cat grooming business. I don't know what's going on in that pizza place. I do know what's going on in that dental office or that medical office or that urgent care place. I do know what's going on there, and we can help those people. If you have someone like that and they're having an issue and you just like to pass them, you can send them through Doug. You just send Doug a note, say, hey, I've got a medical practice. They're having a little issue. Can you guys help? And on behalf of you, I'd be happy to give them some guidance and kind of help them problem solve that one thing. Obviously, it opens the door for us to be able to provide more services. But yeah, you're in the council, man. If you've got medical or dental clients out there and they need help, you can pass them over to us for a one-time solve. Happy to do it.
All right, and the next question, when an employee files a claim for unemployment, what occurs with the business owner? Do they pay higher taxes, higher rates in the future? What should an employer respond to an unemployment claim?
Okay, that's a great question. First, always respond. And typically, we don't check our mail all the time, so we usually have about 3 days to respond. And they don't give us much more than that, like 10 days or so. Always respond and tell the truth. And that's one of those good things about doing those corrective actions and stuff, because the employee will claim that you fired them for no reason, or they'll say, you know, it wasn't my fault, they fired me. I didn't quit, when in fact they haven't shown up for 5 days and you let them go. Yes, when you lose an unemployment claim, it affects what's called your experience rating with the state. It's a small percentage of the taxes that you pay. In other words, the bigger the employer, the more taxes they pay, the larger amount of money will come of this, but they'll still have the same experience rating. So it ticks up and down, and the fewer claims you have, the lower it goes. So you start off with a very low experience rating, but if you have a tough year and you have to lay off people, or you're not great at hiring and you're firing constantly, your experience rating is going to go up, and therefore your unemployment tax is going to go up. And again, if I didn't say it clearly enough in the first place, the larger your client, the more money it is, just by virtue of the base tax that experience rating is applied against.
All right, and the last question is, what is CEDAR's position on independent contractors?
I think I explained that to a great degree. That's the other thing we're going to send to you, is that analysis. There's both an IRS and the Department of Labor, they call it the test. And you have to kind of go through the test to see if they pass the test, and then you take another step, and then you've got to do the hokey pokey, and you step 1 foot in and 3 steps back. But eventually, by using those methods, you can make the determination. Our thing is that 80% of professionals out there who are independent contractors right now are misclassified. Now, does that make us right? Not always. Are there exceptions? There's plenty of them. Can the case be made sometimes that, just pattern and practice, the independent contractor thing's okay? Yes, but for the most part, everybody out there needs to remember, these are taxes that are missing when they are classified as independent contractors, and that's the only reason that the state and the feds care. They know that there are billions of dollars missed because people are able to make, not pay certain taxes, avoid certain taxes as the employer, and as the employee independent contractor, they're able to make deductions that they would not be able to make as a normal W-2 employee. So our position is to be very, very careful, and when we're in doubt, we require their CPA to issue a letter to them telling them, in their opinion, what the classification should be. That's how scared of this we are. By the way, if you're doing business with people in California and you give them the wrong guidance, you're outside of California, if you give them the wrong guidance and tell them to classify someone as an independent contractor, and later it's determined that they were not, the state of California can take action against the consultant who consulted into California and gave the wrong guidance. It just is another aside. If you're actually an attorney in California and you give the wrong guidance, you are not under, you're not in any liability. I guess maybe there are some attorneys in the legislature there in California. Any other questions come up?
Looks like that's all the questions for now.
Okay, everybody. So I'm going to let you off the hook. Maybe you're out of here a little bit early. Thanks. Doug will have another webinar up for you next month. If you have any questions, you can send them to me, Paul Edwards. You can send them to info, I-N-F-O, at Cedar, C-E-D-R, solutions, with an S on the end, .com. That's info at cedarsolutions.com. Send your questions. I'll get them and I'll reply to you personally. And thank you, everybody, for attending. I hope you found this useful.